Good morning. Happy Monday. This is going to be a real quick video. There's been some interest generated, some comments made about my almost 5-hour live stream. If you want all the details, you're going to have to watch it because there's a lot in there. But there's a few takeaways that I think everybody needs to take away. Number one, the only parties to this particular legal action, this legal proceeding, are the state, who are prosecuting Turtle Boy, and Turtle Boy, who is the defendant. They're the only parties. There are also the alleged victims, who are not parties, but none of those are YouTubers. So anybody bringing up a YouTuber or trying to do whataboutisms about some other YouTuber who's not involved in this case at all, you're wasting everybody's time. It's a non-starter. It's grow up, get out of kindergarten, Mom, so-and-so did it too. So-and-so did it first. You're childish. Stop. No one cares. Number two, the court in this particular proceeding, this was law in motion. So the district court made a decision on bail conditions. In Massachusetts, you get a free, essentially it's a de novo sort of petition to set aside, I think it's de novo, but you get to petition to set aside the bail conditions or to have them adjusted by the Superior Court, District Court, Superior Court's above District Court. So Turtle Boy petitioned to set aside his bail conditions. Now, the judge is going to make a decision based on the allegations and facts made in the moving papers, in the opposition papers, and in the complaint, the charging document. Turtle Boy did not, in his declaration or in his moving papers, actively rebut any of the specific allegations that the state made in their charging document. So he fails on the motion practice because of his failure to rebut the allegations. He could have done it in his declaration. He could have set forth, the state says I said X. I actually said Y. Here's a link to the video. Here's a timestamp. The state says I said X. I didn't say X. Here's the video in its entirety. You can see from the start to the finish. I live streamed the whole thing. I didn't say what the state says I said. He could have done that. Instead, he chose to link to Ilhan Omar's Twitter and Alexandria Ocasio-Cortez's Twitter and just stupid things. Turtle Boy tried to play attorney in his declaration, and he failed miserably. And his attorney tried to make points that were unsupported. He tried to make legal arguments that were unsupported. He tried to argue that there was prior restraint. There was no evidence of prior restraint. He tried to argue that the no contact order was overbroad. He had a point in that there was no distance specifically set forth in how far Turtle Boy had to stay away from the victims. So the judge corrected that. Now it's 100 feet, I think. But there's a specific distance. Turtle Boy argued that he couldn't go to court. Apparently the district court, according to the state, had said at the hearing that Turtle Boy could go to court even if there were victims there. So the judge at the Superior Court added that into the order. So now it's actually specifically in the order, in the no contact order, that he can talk to or he can go to court, even if the victims are there. So he has nothing really there. His allegation that the press have some special, pass that they shouldn't be affected by this particular statute, or they shouldn't be subject to these particular bail conditions, had no support in the law. The Turtle Boy made the argument that there aren't any cases on point as far as the press are concerned, because it's never applied to the press. And the judge said, well, in my understanding, it's not applied to the press because the press don't do what you're doing. I don't know that that's a problem. I think that's a reasonable interpretation of the facts, and I don't think that Turtle Boy carried his burden of persuasion to show that there should be an exception made for the press. And finally, Turtle Boy's attorney argued that the statute, the witness intimidation statute, was overbroad. Not overbroad, is it was insufficiently clear. The person of normal intellect would not be able to understand what the statute meant. However, the statute's been around for about 30 years. About 30 years, roughly, give or take. Or at least I could find case law going back about 30 years about it. I didn't do that much research. It was a very marginal amount of research. But there's at least 30 years of case law on it. And the elements of it I broke down in the video. There's 4 separate elements. They're all set forth. They're fairly clear, easy to understand. I don't think that he's going to prevail on that. He didn't prevail on it at the Superior Court level. Now, if he appeals, the Court of Appeals is going to use what was in front of the Superior Court judge, i.e. the charging document, the moving papers, and the opposition papers. That's what the Court of Appeals is going to be looking at. He's not going to be able to adduce new evidence. Now, for those of you who hate Turtle Boy and you think, yay, stick it to Turtle Boy, this is just for the motion. These findings of fact were just for this motion. I just want to be clear about that. They're not going to carry over into the trial itself. At the trial, the state will have to prove to a jury its case. Turtle Boy will have the opportunity to rebut the state's case and try to prove opposing facts to the jury. So the case isn't done. If Turtle Boy had actual evidence that the state's allegations were easily rebutted, that you could just watch a video and it would rebut the state's case, he should have presented that to the judge. He didn't. So either Turtle Boy is incorrect about what he can show or what the state can show, or Turtle Boy and his attorney fucked up. One of the two. You get to decide. Thanks for watching. Have a great day.